Good afternoon, and welcome to the Employer Link webinar series presented by McAfee & Taft. My name is Brad Neese, Managing Editor of Employer Link. Today we'll be taking a closer look at an alternative method of resolving employment-related disputes that does not involve going through the court system, and that's mandatory and binding arbitration programs put into place by employers. Our presenters today will discuss the pros and cons of implementing such a program and offer best practices for crafting a mandatory and binding arbitration program that is enforceable. Before we get started, though, let me remind you about our next event, Employer Link 2013, our annual labor, employment, and employee benefits seminar. It's coming April 23rd in Oklahoma City and April 26th in Tulsa. This year's theme is Government Gone Wild, which reflects the increasingly regulated environment in which there are more rules to follow, costlier penalties and lawsuits to avoid, and increased vigilance required on the part of employers. This year, we have a full-day format. The morning session will include 6 fast-paced, information-packed presentations on labor and employment topics, and then the afternoon session will feature 2 in-depth employee benefits presentations covering new developments in healthcare reform and retirement plans. You can find more details and register at employerlink.com/seminar. Now, just a few notes about today's presentation. This program has been approved for 1 hour of general recertification credit through the HR Certification Institute. For those who pre-registered for HRCI credit, we will be sending a follow-up email in the next day or so with program details for recertification submission. Second, on your screen just below the slide presentation area, you should see a tab called Supporting Material, and that will allow you to download a PDF version of today's presentation materials. You can also find that on our resource page for this webinar at employerlink.com/arbitrate. Our presenters today are McAfee & Taft attorneys Sam Fulkerson and Michael Lauderdale. Both represent employers in all phases of labor and employment law, including disputes before state and federal courts, regulatory and administrative agencies, and arbitration panels. Sam also serves as co-editor of the Oklahoma Employment Law Letter, as well as the Oklahoma section of the annual guidebook for employers and HR professionals called 50 Employment Laws in 50 States. He is a frequent speaker on employment law topics, both locally and nationally. Michael currently serves as co-leader of McAfee & Taft's Labor and Employment Group, as well as on the firm's board of directors. He has also previously served as an administrative law judge for the Oklahoma Department of Labor. He, too, is a frequent speaker and author on employment law topics. So with those introductions, I'll now turn it over to you, gentlemen.
Thanks, Brad. Sam and I thank everyone for joining us today to talk about this topic on arbitration. And the goal for Sam and I today is to do what we always try to do, which is to give you basic, practical advice on the primary topic when you have to deal with lawyers, which is how to avoid litigation. This topic is mainly centered on dealing with litigation once it's presented. What's the best way? Do you want to arbitrate? Do you want to subject yourselves to the jury system? Our initial slide asks each of you, how many of you have settled an employment dispute? How many of you have had an employment dispute knowing that you did everything right? And at some point in time, you sit down with Sam or I or another group of lawyers, and we talk to you about the realities of litigation, that we can't tell you what's going to happen. Even if you did everything right, you're still going to have to go before a juror. There's going to be 12 people in that juror box, and chances are the majority of them are going to identify more with your employee than they're going to identify with management. The fact of the matter is, even if you haven't had any litigation, have been fortunate enough to avoid that, we find that for a medium-sized employer, they're going to get hit with either an EOC charge, a demand letter, a lawsuit once every 3 to 5 years. So even if you haven't been faced with any type of litigation, chances are you will at some point in time. What we're going to talk about today is several main issues. Why do we see a problem with the jury trial system? there are good points, but there's a lot of bad points in dealing with it from an employer standpoint. Second topic we're going to focus on is, should you have a mandatory arbitration policy? Is it a practical alternative? It's not a good fit for every type of business, but we're going to talk about the pros and cons of why you should at least run through the process of considering whether or not this is something that you want to roll out. As Sam and I will talk about, the good news is rolling out an arbitration program is not that expensive and it's not that burdensome. It's fairly easy to do, but it's something that you want to consider with your eyes wide open. And then finally, we'll spend some time kind of on the legal issues. How do you roll out an arbitration agreement? What are the pitfalls in doing so? What mistakes we've seen in rolling out these arbitration agreements? I'm going to turn things over to Sam.
Okay, first, just a little bit of background to give you some focus. A lot of times I'll speak to clients, and Mike will speak to clients, and we'll propose arbitration as an alternative to the jury trial system, and people stop and they say, well, wait a minute, it's federal court or it's state court, and it's the jury trial system, and you've got a constitutional right to jury trial, and they've been around for, the entire time the United States of America has been around, and how can you possibly change something so fundamental? The fact of the matter is, two things you need to bear in mind is jury trials in the employment discrimination lawsuits have only been around for 22 years, since 1991, so they're a relatively recent phenomenon. Number two is arbitration, at least in the commercial context, has been around for more than 100 years. So arbitration is an old, time-tested, judicially enforced dispute resolution process. It's been around for a long time. It just hasn't been applied to the employment context, since probably 1993 was the first time a major company actually went out and formulated an arbitration program and implemented it, and which a company, coincidentally, which is still a client of our firm. So again, arbitration has been around a long time. Employment or jury trials and employment discrimination claims have not been around that long. Before 1991, as a matter of fact, you didn't have very many employment lawsuits at all, because all an aggrieved employee was entitled to under federal law was what we call a bench trial, which means you file your lawsuit just as you do today, but instead of a jury, you're going to have a federal judge sitting alone, and he or she would hear the evidence, and he or she would determine the outcome, and he or she would determine the amount of damages, if any, the employee could recover. There was no jury. Not only that, before 1991, an employee, even if they prevailed, they couldn't really get what we call legal damages, which include emotional distress and punitive damages. Instead, they could recover only back pay, which is their lost wages from the date of termination through the date of a decision in their favor, and in some very isolated instances, front pay, which would be payment of wages into the future for a designated period of time, typically speaking no more than 2 years. And that's pretty much all they could recover, in addition to their attorney fees, of course. So these were very limited types of actions before 1991. In 1991, Congress did a lot when it comes to employment laws. Besides the Americans with Disabilities Act, they amended Title VII to add the Civil Rights Act of 1991. That amendment created the right to a jury trial in employment discrimination claims under federal law. And as a side note, state employment discrimination statutes, anti-discrimination statutes followed suit and allowed jury trials under state laws shortly thereafter. But also Congress amended the law to allow a prevailing plaintiff to recover punitive and emotional distress damages that were proven to have resulted from employment discrimination. So the entire nature of the claim was changed, both as to the decision maker. You're not going to have a federal judge, one person making a decision, and federal judges are by nature not only well-educated and smart, but they're also conservative. So you've got a different decision maker, which is huge, and you have a different exposure as far as monetary losses. You move from back pay and front pay to emotional distress and punitive damages. Since then, hey, here's a big shock, Mike. employment discrimination litigation has exploded. As a matter of fact, that's when modern employment discrimination cases and the employment litigation we're all involved in today, that's its origin. So since 1991, the most recent figures I've seen are that employment discrimination litigation has increased by more than 300%. I think it's frankly increased even more than that. It's really gone from 0 to 100 miles per hour. And certainly in our federal court in Oklahoma City, and Mike and I have spoken with the federal judges here, we know them, we deal with them all the time, their consensus is that at least half of the judicial resources in federal court in Oklahoma are consumed by employment discrimination cases. And very quickly, to put that into perspective, there could be 1,000 different types of lawsuits filed in federal court, but we're talking about 50% or more are employment discrimination cases. So it's a pretty striking number. Okay, so why do employers opt for settlement over trial? Well, there are a lot of reasons, and you probably know them all, but we're going to put them here in bullet point format just to get your thoughts organized. Number one, facts. We may have bad facts, in which case, of course, we're going to pay money. If an employee's rights have been violated, and it happens, and after investigation we determine that it has happened, or to the best of our ability we believe that it happened, then we're going to go ahead and pay some money. But more often than not, we either have rather than bad facts, we have facts that are problematic. It could go either way. So we've got the factual consideration at base. Another factor in why employers settle as opposed to going to trial is the existence now, the commonplace existence of employment practices liability insurance. And once you have insurance, not that it's a bad thing, but you introduce a different actor into the decision-making process. And the insurance carrier is going to, frankly, be concerned about dollars. It's not about facts per se, or about the impact on the workplace, or about employer policies, or about employer-employee relations. It's about dollars. So you've got a different factor when there is employment practices liability insurance. We also have what we call opportunity cost, and as you guys know who have been involved in these cases, it takes the HR and management's time, it takes employee time to prepare as far as investigation and depositions, and there's a lot of emotional investment in these types of claims, because from the employee's perspective, if they've been terminated, we call it an industrial divorce. It's an emotional experience. From the employer's perspective, you're being accused personally of being a racist or discriminated against people because of their disability or their age, all of which are offensive. And so they become very personal. And it takes a lot of time and energy, and that can be better devoted to being productive and running the business. Another factor, huge factor, is expense, attorney's fees. And when we're in federal court, it's the judge who sets the schedule. It's the judge who tells us what to do. It's the judge who tells us how high we're going to jump. We don't have much choice. And that all takes time, and that means it takes money. And then finally, we have the expense of the risk of paying the plaintiff's attorney's fees. If a plaintiff prevails in these cases, the attorney gets his or her fees. If the employer prevails in these cases, as we most often do, we do not get attorney's fees. So you guys are going to have to pay defense fees, and then if you lose, you're 100% certain going to have to pay the plaintiff attorney's fees. And a quick anecdote, Mike, jury trial I had in August of 2012 in federal court in Oklahoma City. The plaintiff recovered $1 in nominal damages, $0 in emotional distress, did get $25,000 in punitives, don't ask me how, but we had to pay the attorney's fees to the other side, which was far greater by several multiples than the actual damages. All right, so those are some of the key factors, all of which I'm sure you've considered, but in addition to that, the huge factor that looms over all of these employment discrimination cases and how do you, the employer, resolve them in the best way for the business is the existence of a jury trial. The decision maker is the jury. It's a group of, it can be 8 persons in federal court, 12 persons in state court, persons over whom we have very little control as far as selecting these individuals. They're going to make the decision, and oftentimes it's very difficult to predict how how they may make the decisions. And I'm not here just to disparage and to run down the jury trial process. Juries serve an important function, and in a lot of cases they do a great thing in resolving very complex matters. But when it comes to employment discrimination cases, the jury pool consists of employees overwhelmingly. They're not members of management. They're not business owners. They are employees. And it puts, in our opinion and experience, an employer at a disadvantage right at the outset of a trial, because the individuals who are going to decide the case and resolve facts, some of which are subjective and some of which are problematic or at least subject to interpretation, they're the ones making the decisions. They're the ones interpreting it. And frankly, there's an employee slant on the evaluation of the evidence. So that makes it problematic. And indeed, the most recent study that Mike and I found shows that approximately 20% of the jury verdicts in employment discrimination cases in the last 3 to 5 years is $1 million or more. And bear in mind that most of these cases where you're getting these huge verdicts involve employees who are wage earners and relatively low wage earners. So there's a real risk in all of that. Okay, so if we have settlement demands or a process involving the potential for a jury decision and a negotiation between defense counsel and plaintiff's counsel about how we're going to resolve the problem, the settlement demands, at least with good plaintiff's attorneys, in my opinion, will come in lower than the sum of all the identified risks that I just described. However, it won't be a lot lower. And what the plaintiff's attorney or the capable plaintiff's attorney will argue with the card they'll play is that, look, you got a jury and you don't know which way the jury's going to go. And if the jury finds in my favor, not only are you going to pay my fees, even if I only get $1, but in addition to that, there's a chance they may go south on you as far as emotional distress, which is entirely subjective, or punitive damages. And because you can't evaluate that risk, what will the jury do, then it weighs an advantage of settling the case now. And from our perspective, and I think from the typical employer's perspective, this is extortion. You've got an employee who files a meritless claim, or one that we consider to be meritless, and they don't have a whole bunch of time or money in it, and you've got a plaintiff's attorney who's capable and can make these arguments, knows which buttons to push, and we are stuck with are stuck with having to determine what is best, knowing that it's going to cost a lot of money in attorney's fees, and you are at risk of an unpredictable decision-making process. So to me, this is the most frustrating thing that I deal with as a practicing defense counsel. I've done this for 22 years. Mike, you've done it longer. It's the single most frustrating part of the process, and it's involved in every case.
We know the plaintiff's lawyers. We work with them on a daily or weekly basis. And if you get one of them to be honest, they'll tell you that they know that by sending a letter to us claiming any sort of wrongful discharge, unlawful activity, that they immediately have us over a barrel, because they know that we're looking at a jury trial. They know what it costs to defend a case. We'll run studies, what does it cost to try a case from start to finish, and those of you that have heard me talk, hear me throw out a number, and right now that number is $140,000, $150,000. And so the plaintiff's lawyers know that. They know that if they can run us through a jury trial, we're going to spend a lot of money. And they're able to hit us with a demand letter knowing that the majority of the time we'll throw some money at them to go away. Now, the plaintiff's lawyer's biggest problem is dealing with their client, because the clients expect some kind of payment, and depending upon the plaintiff's lawyer that we deal with, we kind of know the range of the settlement. But with that jury trial hanging over our heads, economically, we're forced to make a decision, and a lot of times we'll pay money when we shouldn't, when we didn't do anything wrong, which is this extortion problem. So why are we here today? What is a way to flip that dynamic, to take away this threat by an employee and their counsel that we're just going to take you in front of a jury. And even if you beat us at summary judgment, it's going to cost you a lot of money. And oh, by the way, if you don't beat us at summary judgment, which honestly our federal judges aren't giving like they used to, then you're going to pay even more because they know that we're not going to drop this case in front of a juror or a group of jurors on many occasions. So how do we flip that dynamic? Well, arbitration may be an alternative. The law is well established. We're going to talk about that in a second. We can arbitrate claims. The Supreme Court has recognized that. Recently, the Oklahoma Supreme Court, in a rare decision that was taken to the U.S. Supreme Court, was reversed because our Oklahoma Supreme Court judges, which are on the liberal side of the equation when it comes to deciding these issues, refused to send a case to arbitration. The case is Howard versus Nitro, and it involved a non-compete, and the employer and the employee had entered into an arbitration agreement, and the Oklahoma Supreme Court avoided applying it. Similar to California, the U.S. Supreme Court came back in and said, no, you can't do this. You've got to give credence to the arbitration agreement between the parties. You can't just ignore it and try to get around it. And so you can arbitrate claims if you do it right. And as the slide says, what does this do for you? You avoid the jury. You can have a panel of either 3 arbitrators or 1. You'll hear Sam and I talk about later. We are recommending 1 because, as you'll hear us say, one of the cons in arbitration is we have to pay the cost of the employer. It's quicker. It requires less management time. And the last arbitration that I did was last year in December. It was filed in September, and we had a hearing 3 months later in December. That's rare, but these normally do not drag on longer than 6 to 9 months because they move fairly quickly. And the reason is this formality issue. And so you don't have a judge looking over your shoulder. You have an arbitrator. You can pick up the phone. You can call. Most arbitrators are very reasonable, and you can get quick decisions. And so the attorneys know this, so there's not a lot of discovery fights. And you can get to a hearing very fast. And when you get to a hearing, you show up in a conference room, and you have an arbitrator that's at the end of the table. They're on one side of the table, opposing counsel and his client or her client on the other side of the table. You're not worried about offending the judge. You're not worried about what the jurors think. You don't have to pick a jury. And you basically put on your evidence. There's not a lot of objections. Most everything comes in. And it's a very laid-back, quick procedure. The one that I finished, we did in a day and a half, and we had a dozen witnesses. It just goes very quickly, and it's much more streamlined. You note that we put on the slide that very rarely are appeals allowed. That cuts both ways. You can be on the bad side of an arbitration decision. And if that happens, this is one of the cons that Sam and I will talk about. An appeal is about impossible. Now, if you win, it's great because an appeal is about impossible the other way. So there's a very final aspect of we're going to try this once and we're not going to have to deal with it again, which I think is in favor of the employer. I'm not going to speak a lot on this because we've talked about it. It's voluntary, simplified. Selecting the arbitrator is usually the big issue. We'll talk about this. Normally, the arbitration program that Sam and I will draft for you is the parties will attempt to agree on an arbitrator. And 80% of the time, we can usually come up with a mutually agreeable arbitrator. And the reason you want to do that is you want to avoid going through one of the arbitration services, most commonly the AAA, the American Arbitration Association, which charges additional fees and can run up costs. And so the agreement that we will provide will say, all right, the parties either agree on an arbitrator. If they can't, they go through the AAA. And normally plaintiffs' lawyers don't like going to the AAA either, so we can usually figure out an arbitrator in advance. I've touched on this. What is it? It's an informal trial in front of an arbitrator. We talked about it. You have it in a conference room. It's formal. This expense issue, to be honest with you, we have not found that an arbitration process normally results in a significant decrease in cost or attorney fees. Usually it does because you're not filing for summary judgment. You don't get into discovery disputes, but you still have to take the depositions. You still have to prepare. And so I've heard people say, well, it's about half the attorney fee cost of a regular lawsuit. It's not. There are some savings, but you really aren't doing this because you think you're going to save on fees. You're doing this because you're getting out of a jury trial and you're having a professional decide the case. Well, one question we get asked a lot is, this obviously doesn't favor employees. Why would an employee agree to arbitrate their claims? We found that when we roll out an arbitration program, 98% of employees sign up. They don't question it. They're not in litigation mode. They're not concerned about suing their employer. They sign up, no questions asked. The 2% that don't is where you run into a problem. And even if they don't, you've got 98% of the workforce. Now, once the lawsuit is filed, once they have a claim, you can't retroactively force arbitration, so obviously they're not going to sign. So what we recommend is we roll the arbitration program out for all new employees, which is easy. It's just a condition of employment. If you want to come to work for us, one of the conditions is you've got to agree to an arbitration program. Perfectly legal, not a problem, no different than saying, if you want to work for us, here's our vacation policy. If you want to work for us, here's our attendance policy. It's not a problem. Current workers, it's a condition of continuing employment. And so we say that as part of your continued employment with the company, we are implementing an arbitration program. In my mind, it's no different from changing our vacation policy or changing a benefit of employment. Employers can come in and say, from this day forward, you give proper notice, here's our new PTO policy, here's our new health plan. So we go to the employees and say, from this day forward, if you want to stay and work here, we don't fire them if they don't sign it. You have to abide by this program. And we have them sign off. And Sam will talk about later on what we have to do to get a valid arbitration agreement signed, because that's a big issue. For the employees that don't want to sign, we get a list of them back and we tell them, we send them a memo, we send them a letter, and we say, you didn't sign the arbitration agreement. We don't know why. We've, of course, asked them a couple times. And we tell them, from this day forward, if you decide to stay and work here, you're bound by this policy and procedure. And I know Sam has had several cases where that's become an issue, and he's able to convince the court that this is a binding arbitration agreement. And the courts will normally enforce those.
Yeah, that's right, Mike. Especially in Oklahoma, I've litigated, you've got the problematic employee, or he or she puts a hand up and says, why do we have to do this? I'm not going to do it. You can't do this. It's my constitutional right. Well, the answer is, in Oklahoma, if you are an at-will employee, which is what almost every employee is in Oklahoma, and if you show up for work the following day, then whether you sign it or not, or whether you protested it or not, you have, by virtue of having shown up for employment and drawn a paycheck, you've agreed to the program, and you're going to be bound by it. And the issue is in contract law, not to get too much into the weeds, but in order to have a binding contract, each party has to give the other some valuable consideration, something of value. And here, the employer is giving continued employment. That's the consideration for the agreement to arbitrate, and the employee is agreeing to arbitrate. That's the consideration that they're giving us. And some other states, continued employment is not enough, but just like some additional training, additional specified training, some nominal amount of money will be enough to bind the employee to the agreement. Okay. So the bottom line here is, are agreements enforceable? Absolutely. When they're properly designed, they are, and it's not too tough to design them properly. We've done it a number of times, and you guys have probably seen some. It's fairly commonsensical at this juncture. Also, too, these contracts are all drafted under the Federal Arbitration Act, federal statute, which was, as noted, enacted to protect private arbitration agreements, and originally in the context of commercial arbitration, but it's been expanded to employment discrimination arbitration, and there is no question that when these agreements are subject to federal law, they are enforceable. Just as an example of that, there's been a recent federal court decision out of Tulsa where the arbitration agreement was enforced, and it was a Volkswagen of Tulsa employee. She signed an arbitration agreement requiring this mandatory arbitration. She later tried to file a federal lawsuit alleging employment discrimination in the federal court in Tulsa. Volkswagen asked the court to stop the federal proceedings and to force the employee to bring her claims in the arbitration forum. Plaintiff, needless to say, resisted and said that the arbitration agreement that Volkswagen had made her sign was invalid because it said that in the event she loses, she was going to have to pay a lot of the fees, and that would be an undue financial burden on her. She also argued that the Volkswagen arbitration agreement reduced the amount of time in which she could bring a claim. And typically speaking, you've got up to 2 years in these types of cases, or in the type of case that this particular plaintiff brought. The Volkswagen agreement said she only had 1 year to bring the claim. So there were a couple of arguments against the Volkswagen arbitration agreement that had some merit, frankly. The federal court in Tulsa looked at it, and they said, notwithstanding these two flaws, we're going to enforce this agreement. First of all, the court noted that the Federal Arbitration Act strongly favors the resolution of disputes through arbitration, and that's federal policy. And so the courts look for a way to enforce these kinds of things. The federal court also went on to recognize that a lot of Oklahoma Supreme Court and a lot of Oklahoma federal courts and the 10th Circuit Court of Appeals, which is our controlling federal court, have enforced arbitration agreements similar to Volkswagen's in the recent years. Then the court said, even though we've got these issues with the arbitration agreement, here's what we're going to do. We're going to strike that reduced time limitation, and we're going to allow her to bring her claim notwithstanding the 1 year limitation. In other words, the court it found a way to reform the agreement to make it enforceable, which is very striking. And number two, Volkswagen, their attorneys, very smartly said, hey, you know what it says about she's got to pay the fees if she loses? Well, we didn't mean that. We're not going to enforce that. If she loses, we're not going to go after her for fees. In other words, they recognized that it was a bad provision, and they agreed to waive it. Strikingly, the court said, oh, okay, we'll let you do that. The point of this case is that the court went out of its way to find a way to enforce the arbitration agreement.
Sam's going to talk about this issue in a second, but one of the key elements in a mandatory binding arbitration agreement is to make sure that federal law applies, because the Oklahoma Supreme Court, if it gets hold of the issue, is hostile to arbitration. And if they get an opportunity, they will blow up an arbitration agreement. So we have to make sure that federal law applies, and that even if we are in state court, the state court must apply federal law. Now, we're kind of sprinkling in pros and cons as we talk through this today, but in my mind, one of the major pros to having an arbitration program is that if you hook any plaintiff's employment attorney up to a lie detector and you ask them, are they in favor of arbitration or not, the answer is going to be no. They won't tell you that because they don't want to admit that you have leverage on them, but they hate arbitration. And just having an arbitration agreement is a major, major deterrent for having someone pursue an employment discrimination claim.
And just to amplify on Mike's comment, that's because plaintiffs' lawyers, like all lawyers, but especially plaintiffs' lawyers, are businessmen. And how do plaintiffs' lawyers make money, Mike? By settling cases, not trying them. Because to try a lawsuit takes a ton of time, and you can't focus on all the claims. You got to focus on one claim, and it's all or nothing. So you don't make money by trying cases. You make money by settling cases. And if you have an arbitration agreement, you've taken their biggest leverage away, which is, well, you don't know what the jury's going to do. So they can't make that argument, and they're really at a disadvantage.
And their clients never tell them they signed an arbitration agreement, and it's always a surprise. In fact, Sam and I get to have a lot of fun when we get to call up the other lawyer and say, oh, by the way, did you know your client signed an arbitration agreement? Silence on the other line, and we get to send that to them. Now, one of the cons that we'll talk about later is that the EOC is not bound by the arbitration agreement, and so it's not something that we have to make a decision of when to disclose the fact that there's an arbitration agreement out there. But plaintiffs' bar do not like arbitration agreements, and so knowing that, if they think that they have a very good case, they will attempt to invalidate the arbitration agreement. And so let's talk about ways to make sure that you will implement a valid arbitration agreement that won't be subject to attack.
Okay, and this is a quick checklist, and you're going to have these written materials, so we don't have to spend a lot of time on them, but we need to run over them just so you're familiar with them. The first note here is the Federal Arbitration Act applies only to a written provision in any contract, and we want to be under the Federal Arbitration Act because federal law enables us, if we have federal law at play, it enables us to get one of these claims in most instances out of state court if it's been filed in state court, and we can get the federal court to enforce the agreement, but it's got to be in writing, and that means it's got to be obviously some sort of a contract. And obviously, as a result, the best practice is to prepare a separate document meeting the definition of a contract, and that's not a difficult thing to do. And it needs to be a separate document in the sense that it really shouldn't be part of the handbook. And there's case law out there where there were arbitration agreements in a handbook, and the arbitration agreement just read alone was okay. But there were other provisions in the handbook that were contradictory, and it was all part of the same document, so the court invalidated the arbitration agreement because other parts of the document, in other words, the handbook, seem to supersede the arbitration provisions. So you don't want to tuck it in there. You want to make it a separate document, a separate writing, a contract, and that means, of course, that it needs to be handed to the employee and they need to sign off on it. Okay, in order to meet the definition of a contract, the arbitration agreement has to have some consideration. We've already talked about that. The consideration is something of value. The thing of value that the employee gives is the agreement to arbitrate. The thing of value that the employer is giving, at least in Oklahoma, is continued employment, or for the new employee to hire the individual to become an employee. There just has to be benefit on both sides, and it doesn't take a lot.
And so, one issue that comes up is, well, what if we want to change the arbitration program? And one item that we're doing now that we're going to talk about in detail later is what I'm going to call the class action issue. The second biggest pro to implementing an arbitration program is to bar class action. And there are some issues with that. Basically with the NLRB, and Sam and I will spend some time in a few minutes talking about that because we believe that having a class action bar is a tremendous, tremendous advantage in an arbitration program. And the Supreme Court and other circuits, let me back up, other circuits have said that these class action bars are valid. The Supreme Court is currently deciding an issue on non-employment-related class action bars that may change that landscape. But right now, you can bar class actions. That is critically important in wage and hour issues, Fair Labor Standards Act, because those are coming. We're seeing those. And by not allowing the employee to represent a class, it greatly diffuses the threat of wage and hour litigation. You've also probably read about the Walmart case where the Supreme Court struck down that class action, but we're also seeing threats of class action for age-related cases, national origin discrimination, sexual harassment. By having the individual sign the class action waiver, he or she can't represent the class, which takes a lot of sting out of any further threat of bringing a class action. But as noted in the slide, we can change it. You got to give notice. You can't affect current claims. So that's not an issue.
Yeah, and the notice given typically is about, as long as you give at least 10 days advance notice that, hey, we're going to change the program and here's how we're going to change it. If you post it in the break room, or if you give some sort of written supplement to the employee, what the courts have said is that gives an employee with a current claim, or what they think is a current claim against their employer, it gives them the opportunity to go ahead and assert that claim under the existing arbitration agreement before, in other words, before it's changed. So we have to give them some time to do that, but it's not a great amount of time. So even if an employer provides consideration in some other form, we do need them to be mutual. And for purposes of this slide, what I mean by that is, it is, I guess, theoretically possible that you could have an arbitration program that says you, employee, will arbitrate any claims against the employer, but the employer reserves the right to bring a lawsuit against you in court and seek a jury trial, for example, if you were to engage in some misconduct or embezzle money or whatever the case may be. That is ill-advised. It is a huge red flag. It is something that some plaintiff's attorney will attack and say this is a basis to undermine the agreement because it's not mutual. You're making the employee do it, and yet the employer is not agreeing to do it, and that's just not cricket. It's not fair. I think you might be able to get away with it in front of some judges. We do not advise that you do it, though. We think that employers need to be subject to the agreement also. The fact of the matter is, practically speaking, it's not that often that employers pursue their employees in litigation. It just doesn't happen, number one. And number two, even if you have a valid claim, it's a waste of money. You're throwing money down a hole. So you need to consider this mutuality. We think that the employer should be subject to the agreement just like the employee. Another essential element is what we call exclusivity, and the arbitration agreement has to simply state that it's the exclusive avenue for dispute resolution. Believe it or not, if you don't have that word exclusive in there, the courts may say, or a particular judge may say, well, you're not saying it has to apply, therefore the employee's not bound to it. So this is a simple thing, but make sure that you do it. Also, every employment arbitration agreement should expressly state, as I've mentioned, that it's subject to the Federal Arbitration Act, and it should not reference state law. You want it to be federal law. You also want every employment arbitration agreement to state that it is subject to and involving interstate commerce. Now, the reason for that is if it's involving interstate commerce, then it's definitely subject to the Federal Arbitration Act. It doesn't take much for an employer to be involved in interstate commerce. As a matter of fact, I can't imagine, frankly, or come up with an employer that's not involved in interstate commerce. It would have to be an employer where every single aspect of its business function is done within the state of Oklahoma, which means it can't make a telephone call outside the state of Oklahoma. It can't buy any sort of a product from outside of Oklahoma and have it shipped to it or mailed to it. It takes a very minimal amount of interstate activity to be involved in interstate commerce, and that in turn enables us to say, well, we're subject to the Federal Arbitration Act, which is, again, very favorable for employment arbitration. Every agreement also should state that it's, I think, and there's some disagreement here, but not much, but that it's governed by the rules of the American Arbitration Association or some other respected arbitration organization. There are a handful of them. JAMS is another one. I prefer the AAA. Now, back to Mike's point earlier that you don't necessarily have to go through the AAA because it does incur some administrative fees, and if you want to do it as economically as possible, you can avoid that by agreeing upon an arbitrator, and you can go ahead and have your process, and you can do it without this administrative expense. Nevertheless, you could still state that the parties agree to follow the rules of the AAA, which have a subset of rules that are expressly designed for the resolution of employment discrimination claims. And they're very neutral, they're very fair, and I strongly recommend that you put that in your arbitration agreement.
On covered claims, we like spelling out that any claim between the parties is subject to arbitration, and then we'll usually list out the typical claim just so there's no dispute. We want you've got to decide if you want to expand your arbitration agreement to the hiring process. That can be difficult because, as Sam has talked about, you have to have a contract. And so when someone is applying, do you make them sign the arbitration agreement? That's just an issue that you have to talk about. One area where we've had some employers get tripped up is when someone leaves and comes back, or if someone is terminated or quits and comes back. And many employers will forget to have them sign a new arbitration agreement. And recently we've had a federal judge say, well, that agreement covered the old claims. Now you've got a new employment relationship. You didn't have him sign it again. We disagreed, but he found that we could not subject that employee to arbitration. So if there's a break in service and employment, make sure and have them re-sign the agreement. There's a few items that we carve out. If there's a collective bargaining agreement, work comp, you want to go through the work comp system. Unemployment, you want to go through the OESC. There's really no way to effectively arbitrate those, and so you carve those out for those reasons. A key issue is distribution, and Sam's going to talk about that.
Yeah, I mean, it's common sense, but what the courts have decided over the years is that you can't just have an agreement and not give notice to the employee, and we recommend a separate arbitration agreement in addition to a handbook. We recommend that a physical copy be given to the applicant and to the existing employee. We recommend that it be posted in the work or in the break room or in a place where the employee will take note of it. But physical distribution, and that now includes electronic distribution, as long as you have a proper chain of custody showing that it was transmitted and that the email was received and that the document was opened, or at least they had the opportunity to access it, that suffices too. But there's nothing that is any better than just handing them a copy of the agreement, because it's not a very big document, and saying, here, you've got it. One other part of this, too, is that when they get these things, they need to sign an acknowledgement of receipt, and that is part of the contractual process. You can't have a contract unless the other party has received the contract, is aware of its terms, and has agreed to them. And the way they agree to them is by signing them. Now, one thing that I make of note here is more and more clients are going toward electronic signatures, an electronic transmission of the agreement and an electronic signature. That technically works, and I've had that challenged in federal court, that electronic signatures are problematic. And if you've got the employee where all they do is open the document and they check a box, and then there's an employee ID number next to the box, that can be challenged by a good plaintiff's attorney, where their client's willing to say, I didn't get it and I didn't check the box and you can't prove otherwise, and it's not, for example, a protected computer terminal. It's problematic. And in those cases, the judges are going to be, frankly, more inclined to find in favor of the employee, because they're going to say, if there's no agreement to arbitrate, I can't enforce the agreement. So if you have an electronic signature, think about how you do it, because they can be problematic. I'm old-fashioned. I still like giving them a copy, making them sign an acknowledgement of receipt, put it in the personnel file. And as we've mentioned before, we also take the position in Oklahoma that continued employment is their agreement to subject their claims to arbitration, even if they vocally oppose the arbitration agreement. Okay, also every arbitration agreement has to preserve the employee's rights and remedies under the law at issue. For example, if somebody sues for disability discrimination under the Americans with Disabilities Act, our agreement can't curtail or change or limit the employee's rights, and it also can't change what they can recover in the event they prevail in arbitration. In other words, the claim's identical and the potential recovery is identical as in federal court, except in arbitration, we are in a different forum. It's in a conference room, and we have a different decision maker. It's the arbitrator. So we're not changing the law. We're not changing the right of recovery. We're changing the location, the forum in which the dispute will be resolved. Also, too, every arbitration agreement has to preserve the employee's rights to discovery and the proper rules of evidence. And again, that's something that's included in the AAA's rules, which I highly recommend being included in all these agreements. Every arbitration agreement has to preserve the employee's right to be represented by counsel, of course, at their expense. We need to make sure that that is in the arbitration agreement. And then, Mike, you want to talk about the arbitration cost?
And this is a good time, Sam. Well, let's jump into the pros and cons, because I think that's important, and payment of cost is one of the cons. So, Brad, if you'd go to the arbitration agreement pros slide. All right, why do you do this? We've touched on a lot of the pros as we've gone through this, and I'm going to run through them and then let Sam talk about the cons. Number one pro, avoid the jury. Plaintiff's lawyers don't like that, obviously. Simplify the settlement process, because the fact of the matter is it's still going to be expensive, even though one of the pros is its cost savings. We have to pay for the cost, which Sam will talk about. But this is just a massive settlement deterrent. Once I pull out that arbitration agreement, the case doesn't get good. We're normally able to resolve the case for a very, very reasonable amount. You pick an arbitrator who knows employment law. It's not automatic, but it takes emotional and punitive damages out of the equation. Arbitrators rarely award those. And the fact of the matter is, if we've got a case and we're not perfect all the time and we can't control all our employees, but if we've done something wrong and we think there's a threat of emotional or punitive damages, we will usually talk with you and we'll all agree to resolve the case before all those bad facts hopefully haven't come out. So chances are, if we end up going to an arbitrator, it's probably a pretty good case, and we're not concerned of a jury flipping out, like in Sam's case where they awarded punitive damage. That's the same thing happened. I got a $8,000 judgment, and all of a sudden they're awarding punitive damages because the jury instructions are very unclear, and they gave $100. That never happens with an arbitrator, and the plaintiff's lawyers know that. So punitive and emotional are off the table. Arbitrator awards are 1/3. That's why. No punitive, no emotional. Cost and time savings we've talked about. We've talked about informality. We've talked about finality. Privacy is key. None of this is in the public record. There's no court filings. We don't have to worry about that. And then finally, again, this barring of collective or class actions. In my mind, that is the number one reason currently that you should enact an arbitration policy. It may get blown up. The National Labor Relations Board, who has been more active in non-union employee issues, have said you can't do this, although no federal court has agreed with them. Plus, there's a jurisdictional question right now about any of their decisions. They've been very active in the Facebook, social media issues, and they've also found that you can't do these class actions. That doesn't mean you can't do it, and we recommend that you do, but it's a major, major deterrent. Let's talk about the cons. Why would you not do this?
Okay, well, and these are some of the things that historically have been raised. First, there's what we call the split the baby mentality. This really comes out of traditional labor law, out of the collective bargaining agreement and union scenario where we've got labor arbitrators, and even though the guy was a horrible employee and did terrible things, they end up putting him back to work, but they don't give him any damages. In other words, they kind of compromise between the employee's position and the employer's perspective, and nobody's happy with the outcome. And that happens in labor arbitrations, traditional labor arbitrations. Does that carry over to employment discrimination arbitration where we've got the non-union employee? In my experience, no. We get good arbitrators who make a decision one way or the other, and we don't really see these compromised decisions, certainly not in the labor, as we do in the labor context. But it's something to be aware of. Number two is enforcement. If a plaintiff resists arbitration, such as the Volkswagen case in Tulsa, then the employer's got to pay the attorney to file what we call a motion to compel arbitration. Frankly, we've had to do it so much, it's kind of a routine thing here, and it's not a great undertaking or a great expense, but it is an expense. In other words, you're involved in a legal dispute just to get to the arbitration process. Number three, a potential increase in claims. There's always been that discussion out there. I personally have not seen it. In other words, if you have a really easy process, it's easy to access, and it doesn't involve a federal judge and a jury, and you don't have that intimidation factor that employees feel sometimes, and if it's right there, and if the employer has posted it in the break room, you're going to encourage employees to bring their claims. I frankly haven't seen it with the clients that have these programs in place. We haven't seen a demonstrable increase in claims that can be attributed to the existence of an arbitration program. But it's something you need to think about. The next one is a little more real world, and that's the loss of the pure legal argument. And the bottom line is I've moved for summary judgment in arbitration probably once, maybe 2 times in 22 years of doing them. You just don't do it because the arbitrator is going to be inclined to not rule on the motion or to deny the motion and say, we're an arbitration, guys. It's a faster and generally cheaper, certainly quicker dispute resolution process. Let's just have a hearing. Let me hear the witnesses. Let me look at the evidence myself, and I'll make a decision. That's what arbitration is all about. And that's the way it works. If you're in arbitration, you're probably not going to have the basis for a summary judgment motion, which means you're going to have a hearing if you don't pay some money. It's one or the other. We also cannot bar the EEOC from an investigation. So even with an arbitration program in place, the employee can go to the EEOC, file a charge, and theoretically the EEOC could bring suit on behalf of the employee against the employer. But as we all know from experience, the EEOC rarely does that. So we're still going to have the EEOC administrative process. We can't prohibit that. But 99.99% of the time, you go through the motions, it's dismissed without cause, and then you proceed to arbitration. Finally, will Congress prohibit mandatory arbitration? Before the Great Recession of 2008-2009, that was a serious question because there was a lot of move afoot in Congress to do it. That's all gone by the wayside. I have spoken with a couple of congressmen in the last year or two. What do you think about that? And they just laugh and say that's not on anybody's radar screen for the foreseeable future. It's not going to happen. Congress is not going to keep an employer from having one of these programs in place. And just very quickly, we've got 2 minutes. I want to go back over a couple of slides that we did go over. I think we've covered them, but just to make sure there aren't any questions, going back to what I have is slide 31, and it's the question, should all employees be subject to mandatory arbitration? What I say, even C-suite executives. The bottom line is this: can you exclude classes or a group of employees from an arbitration program and still have an enforceable agreement? For example, exclude all of senior management from the program and let them sue in the event they think their rights have been violated or if they have a compensation dispute. Theoretically, yes. Practically speaking, I think it's poor policy, bad practice, and it creates a lot of morale issues among employees. I don't recommend it. Next slide, I believe, recommended elements. One thing I want to note is the third bullet point. In these arbitration agreements, and Mike and I will take care of this for you, we carve out injunctive relief. Bottom line, all of the claims, legal claims, have to be brought in arbitration rather than the court. But if you're a sales representative and you've left and you've gone to work for a competitor and you've stolen our information, we still have the right to go down to the district court and get a temporary restraining order against you, and then we'll arbitrate the issue of whether or not you breached your contract. So we want to carve that out. The next thing, too, and I want you to consider this because to me this is the best part of an arbitration program. It's not just arbitration. It's at least a 4-step program. First of all, you have a stated policy of open door. Go talk to your manager, the manager's superior, upper management, whatever the case may be, to try to resolve it informally. If that doesn't work, have an internal mediation program. You could have a panel of co-workers or peers be informal mediators. This is done surprisingly common in my experience, very effective dispute resolution process. If that doesn't work, we'll have an external mediation with an independent neutral mediator. And again, that works a lot of the time. It's very low cost. And if those 3 steps don't work, then we'll go to arbitration, but it's going to be last resort. If you have this kind of multi-step plan, I think that you're going to head a lot of these claims off at the pass. And to me, this is a really big factor in favor of arbitration.
Before we close, just a few quick reminders. First, you'll soon be getting a follow-up survey about this webinar. We ask that you take a few moments to complete that questionnaire. Your feedback helps us improve our events as well as letting us know what topics and issues are on the minds of our participants. Also, as I mentioned earlier, those who pre-registered for HRCI credit will receive an email in the next day or so. And then later this afternoon, an archive version of this webinar broadcast will be uploaded to our webinar resource page. The downloadable version of the presentation materials are also available there. You can easily access that resource page from both employerlink.com and maxfieandtaft.com. I want to thank again Sam Fulkerson and Michael Lauderdale for presenting today's webinar. And on behalf of the law firm of McAfee and Taft, thank you for joining us for another Employer Link webinar. Mike, did you?
Yeah, and there may have been a couple of questions that we didn't get to. Feel free to email Sam or I directly at our email addresses with any questions you have, and we'll definitely get those questions answered and get back to you.
And that'll wrap it up. See you next time, and have a great afternoon. Thank you.